In 1987, Congress threw their hands up with national crime. They were beside themselves, and they said, we have to do something about it. So they enacted the Sentencing Commission, and these folks got together and they became very serious and very tough on crime very quickly. And the war on crime began in the country, 1987, through Congress and the Sentencing Commission. And one of the focuses of this war were narcotics cases. And when we get into the lecture a little bit, you're going to see how serious a little bit of drugs is in the federal building, much more so than in the state, notwithstanding the strict Rockefeller laws. So it's an interesting lecture because you folks, are you lawyers or law students? Lawyers, right? New lawyers, yes, for the most part? How many people here have tried more than 10 cases? All right, so other than the cricket, no one, right? All right, so it's important for you especially because you're going to get that phone call at 6:15 in the morning. Your neighbor's wife is going to call you one day, if it hasn't happened already, I don't mean to be presumptuous, and is going to say, oh my God, there are 15 federal agents in the house, they've kicked the door in, my husband is in pajamas, look out your window, you could see him going to the black Range Rover, he's in handcuffs, what do I do? And the point of this lecture is to help you with that phone call. No one's going to become an expert between now and 6 o'clock, right? But it's going to help you to deal a little bit in the area of how to represent someone in federal court when they're charged with the unthinkable. And it really is, with respect to the penalties, it's the unthinkable. A little bit of drugs puts you away forever. It is that serious. And, you know, to go forward to the trial for a moment, because every time we get that phone call as lawyers, what we should be thinking about from that moment is the trial. Because you can't help someone on D-Day if you don't understand what D-Day is. We have big choices to make as lawyers. How are we going to effectively help someone who's facing life in jail? And most of my clients, when it comes to the narcotics cases at 500 Pearl Street, are facing life in jail. They're in a B1A range of Title 21, United States Code, Section 841. And what that means is there's a mandatory statutory minimum of 10 years if convicted and a maximum of life. So they're all facing life. And we have choices to make on how to help them. One way to help them is to go forward with the trial eventually. Right? We hope we're not on the rocket docket. We have a chance to look at the Rule 16 discovery, make all the appropriate motions, meet with the client enough, because trust me, he's going to be in the MCC. You're not going to be, going next door and having biscuits and tea defending the case. Because when we talk about bail, which hopefully we'll get to, I mean, this lecture really is like a 6-hour lecture, not a 3-hour lecture. So I'm going to try to cram all the goodies into 3 hours. By the way, who wants to listen to me for 3 hours? Are you guys getting credit for this? CLE credit? So that's why you're here. It's not to learn, is it? You're here for the credit. I knew it. So we're going to try to do the best we can in the next 3 hours. And one of the topics might be bail. And I'm not the type that reads off the cheat sheet. I'm gonna catch your vibe and see what you want and what you need, and that's what I'm going to teach. But if we do get to bail, you'll see that there are presumptions in some cases that no condition, and I'm quoting the Second Circuit now, Court of Appeals, right, above the district court. There's no condition or combination of conditions that can reasonably assure two things in federal court. One, return to court, right, because there's always a risk of flight issue. Judges don't like to let our clients go, and then they say, bye-bye, I'm in Colombia, no offense to the Colombians, right, and danger to any person or the community. There's a presumption in these B1A drug cases that there is no condition or combination of conditions that can reasonably assure me as the judge that you're going to come back and that you're not going to hurt other people. And even if there's no violence per se in the case, drugs are what? They're killers. They're inherently dangerous. And so a drug dealer suspected, is dangerous. And Congress says it, and that's what it is. So you'll be meeting your client for Coca-Cola from the vending machine in the MCC in Manhattan at 150 Park Row, or the MDC in Brooklyn at 129th Street, the new or the old building, and you'll be preparing your defense. But how do you do it? Well, you have to know what the trial might look like, right? So here's what we have. Who in the room is for drugs and guns? I know some of you are, by the way. You just don't want to admit it. So nobody, right? And you should know I travel around the country thinking I'm important, trying cases and representing the wrongfully accused if they pay. And, I know a lot about different jurisdictions, but I could tell you that a Manhattan federal jury does not like drugs and guns. And there was a time where you might be able to get away with that in state court in the Bronx. No offense to Bronx people. I come from the Bronx, actually, originally. But even that jury pool has changed since I started practicing a little more than 10 years ago, trying cases up in the Bronx and elsewhere, because those folks are sick of it too. And everyone has at least a 2-year associate degree. When you voir dire the juries, you'll see that. Everyone's working, everyone's professional. The welfare state of the 80s and 90s is no longer in New York. There's responsibility, there's accountability, and people don't like it. And you as lawyers representing folks accused of narcotics offenses have to know it. And everything we do when we walk into a courtroom and we're going to try a case, and Clarence Darrow, my hero, the greatest modern American lawyer, other than Johnny Cochran, I don't know how he got away with that. God rest his soul. He said that lawyers are trial lawyers. Real lawyers are trial lawyers, and I'm paraphrasing. They walk into court and they persuade a body of people of a point. And that is what we do. We persuade. So instead of standing up here, and we'll get to the nuances, but just hitting you and peppering you with nuances from 3 p.m. to 6 p.m., I really want us to look at the big picture. What we do as trial lawyers is we walk into a tribunal, we say hi to a bunch of strangers, we try to make them like us enough to believe what comes past our lips, we try to dispel the myth that everyone who sits in the hot seat is guilty, and we try to get through to them. We try to persuade them. But how do you do it in a federal narcotics case when everyone is against it? Well, first off, you have to know it. You're up against this mountain. They want your client to go out the back door, not leave through the front with you, and you have to do something about it. Now, there's drugs, and the government will bring the drugs on the day they're going to introduce them into evidence, and they'll slap the drugs on the table. So picture it. A mountain of white is on the table next to the jury, because of course they get the table, the federal prosecutors, right near the jury. We get to sit in the back somewhere, because we don't count. So you got a mountain of white. There's usually a nice heavy clunker, right? A nice gun that's sitting there in a plastic bag with like one of those plastic strips so that it can't fire, God forbid. And it looks dangerous, and it is dangerous, and it's sitting right there on the table, and the jury can't help but stare at that. So that's what we're up against. You have a client who probably cannot testify. By the way, no one commits suicide because it's going to get better. But you have a client who can't testify, and the reason he or she can't, I say he because it's usually a he in my practice, but it could be a she. No offense to the women, right? You can commit crime too. But he can't testify because if he testifies, what will he be cross-examined with? He's going to be cross-examined with all of his criminal convictions. He's going to be cross-examined with the underlying misconduct on the crimes of moral turpitude or dishonesty. And that's usually what we see in the narcotics cases. The client, for whatever reason, I guess I don't get them fresh and young. I get them when they have 2, 3, 4 convictions to their credit. So your client can't testify. If your client testifies, and if your client is convicted, and if we believe the statistics, there's always a 90-something% rate of conviction, 96